I'm going to introduce the prosecutors who are here today. The reason this part of the conference, and really the conference itself, is called the dialogues, is because we have this dialogue. And for years, I've been fortunate, with a couple of exceptions, to be the moderator of the dialogues. And the way this works is we ask them very short questions about modern and contemporary things that are going on in their tribunals. And you get a comparative glimpse, not just of the ancient history of the tribunals, but a snapshot of what's going on right now. I do need to note that this is being live, it's being live streaming, and that means that anything you say is in the public domain. Last year, one of the prosecutors wanted us to edit things out, but it's gone already, so that can't do that. So let me introduce the prosecutors that we have here, starting with Mohammed Gura. Next to Mohammed is Fabrizio Berglia. We all mispronounce her name. How about if you tell us how to pronounce it correctly? Wadli. Okay. From the International Criminal Court. Then next to Fabrizio, who I've known for years and years, is Norman Farrell. Norman, is this your first time here?
First time as the prosecutor.
As the prosecutor. That's fantastic to have you here. And then next to Norman, we have Kevin Hughes. Norman's at the Special Tribunal for Lebanon, the prosecutor. Then Kevin Hughes, the Mechanism for International Criminal Tribunals, which is, as you know, the Yugoslavia and Rwanda Tribunals residual mechanism. And then we have Nicholas, and I always damage his name too, but I think it's Kumligen, sort of. So, he's been teaching me it for years and years. I still mangle it. But of course, Nick is, and you saw his presentation last night, he's the current Chief Prosecutor of the Extraordinary Chamber for the Courts of Cambodia. So without further ado, we're going to launch into these questions. And I will start out with a general question for everybody, but then I would like one or two prosecutors, maybe three, to answer the questions if you believe it's particularly relevant to your to your tribunal. And you'll see that we don't get through many of the questions because it always gets bogged down. But let's try to keep it moving fast. And then we want to have 15 minutes of Q&A from the audience at the end. So the first question, can you describe what you consider the most important developments at your tribunal during the last year? Let's make it development singular so we can move it along. And we'll start with Mohammed.
Yeah, thank you. The most important development in the...
Yes, bring it right to you.
The most important development in the residual court over the past year was a decision given in an application for conditional early release of one of our prisoners, and that is a prisoner called Aliyu Kondewa. The special court has got provisions for prisoners to apply for early release upon having served 2/3 of their term. But he's not the first who's been granted early release. If we're keeping it to within a year, that's the most important development. But that decision was subject to a delay. The judge ordered a 10-month delay for him to get further training in basically understanding how to get integrated back into society and understanding the importance of the process by which he got convicted in the first place. And that was important because he's the previous prisoner who got released had similar conditions applied to him and had training as well, but no sooner was he released than he broke one of those conditions. And even in his case, there was a delay provision of 6 months for training and for him to understand the process by which he had been convicted. But notwithstanding that, he broke one of those conditions, got involved in politics, which is one of the main conditions on which you're released. Basically, when you're released on conditional early release, you're not completely free. You still have that part of your term to serve, but in a more open and supervised environment. And so that's the most important way.
And this is an issue that we can return to because later on, because many of the tribunals are now having the equivalent of early release. And even those that are in jail seem to be finding ways to violate the conditions of their jail term. I understand that Charles Taylor has been making phone calls where he's been threatening people throughout Africa Who knew? So let's go to Fabrizio.
Thanks, Michael. I think I would name, well, first thing is, on behalf of Fatima and Sura, I would really like to express the gratitude of the office for being invited once again to this event. She sends her regards. Normally, this is the first time in my entire life that people tell me that they can't hear me, which is good. So, again, on behalf of Fatima and Sura, the Chief Prosecutor of the International Criminal Court, we want to express again our gratitude to the organizers for inviting us, having us again to be able to discuss with you what we do and how we're doing it. She sends her regards, she expressed her regret for not being here, and she apologizes for the representative that she sent, but I was the one that was not there. I will name 4 big developments, I think, from last year, in no particular order, but the first one has been the conviction of 5 accused in a bit of a spin-off from the Bemba trial. There's been a conviction of 5 accused for offenses against administration of justice, including Chief Counsel for Jean-Pierre Bemba and the case manager, plus 3 other indictees. And it's the first time that we bring a case against a group of people for offenses against administration of justice. In their case, basically the crimes charged all related to the presentation of false evidence at trial, around 14 witnesses that were basically the testimony was fabricated. And I think it's the first time ever that the International Criminal Jurisdiction presents a case of this magnitude, involving basically the leading counsel and a part of the defense team, plus associates. And in our case, I think the important thing is when we realized the level of corruption that had been reached, we just simply said, well, this is not something that the Office of the Prosecutor and the institution as a whole can tolerate. So we need to send a clear and strong message that this type of behavior will not be condoned. This type of litigating before international criminal jurisdiction does not entail that you are free from all the ethical rules that bound your activity as defense counsel. And the fact that you are defense counsel doesn't mean that you can get away with murder. So I thought it was basically, we felt there was an important conviction and one that we hope will deter similar conduct in the future. The second one has been the conviction of Al-Mahdi for the crimes of destruction of cultural and religious property in Timbuktu. I think it's important on a double sense. First, it's the first time that there's an international case put forward that is only addresses, or it's only based on the destruction of cultural and religious property, without any other crimes charged. And I think it's important because in the same way that in Lubanga we wanted to put the limelight on the suffering of the child soldiers and the fact that that suffering was usually viewed as some sort of second-class type of victimization, when we want to say, no, this is a terrible thing, it destroys children's lives. This has to be given the importance that it has, and it has to be treated as a grave crime that it is. We want to do the same thing with the Al-Mahdi case. We wanted to put the centrality of religious and cultural property to the communities involved. And I think that one important thing that came out from that small trial, because I'm going to address that in a second, was the fact that it became clear how much impact the destruction of the shells had had in the community in Timbuktu. How key those objects were to the community's life, and how much it has suffered as a result. An important thing as well is that this was the first time that we had an admission of guilt in the ICC. We don't call it guilty plea, we call it admission of guilt. That's the language of Article 65 of the statute. And it was important on a number of factors, including the very significant expression of remorse by Al-Mahdi himself during the short trial that we had, lasted I think around a week. His apology to the communities for the crimes that he had committed, and his encouragement to others not to engage in that type of conduct in the future. So that was also an important development. We started the Ongwen trial. Ongwen, as you may know, is one of the commanders of the Rhodes Resistance Army for crimes committed in northern Uganda, primarily. It's a very important case. The case was dormant for around 10 years. And then when Ongwen turned himself over, we had to relaunch investigation and basically fill in all the gaps and resuscitate some of the evidence. It's a trial that is very important in a number of ways, but it has a very significant component of sexual violence. It has a panoply of different forms of sexual violence that have been charged. It's the first time that forced pregnancy as a crime against humanity is charged internationally, so in that sense it's also a first one in the ICC. And lastly, one ruling, we're talking about international humanitarian law earlier today, there was one ruling that is particularly important, I think, for the development of international humanitarian law, and that has been the Peace Chamber's ruling in the Ntaganda case, where the Peace Chamber has said that for rape and other forms of sexual violence, there is no requirement that the victim belongs to a different party than the perpetrator. So there's no requirement that the victim of rape be a member of the opposing party in an armed conflict, so there can be rape as a outcome of your own rank and file. And this was a very significant development. We didn't charge, this related to the sexual violence inflicted on the child soldiers in the Lubanga case. The Ntaganda case Ntaganda was Lubanga's number 2 in the FPC UPLC. And one important aspect is, I think, the learning curve of the Office of the Prosecutor. Because we initially looked at this conduct in Lubanga, we said, well, doesn't sound like a war crime. Then when we were looking into Ntaganda, we said, we probably have a very rudimentary understanding of this. This may require a more sophisticated approach. So we engaged in a wide range of consultations with different experts, and we reached the conclusion that actually, contrary to common assumptions, there is no overarching requirement of adverse party in IHL. In some aspects of IHL, yes, but not in all of them. And that was a position that we put forward, which was first adopted by the trial chamber, and then the Peace Chamber, what we feel is a landmark ruling, confirmed this. And I think it's an important ruling that will expand the protection of international humanitarian law. It has to be borne in mind, though, that the Peace Chamber is primarily applying treaty law. It's primarily applying Article 8 of the statute. But it also examined, because the chapeau of Article 8 of the statute requires the Chamber to do that, it also examined the principles of IHL in general, and it reached the conclusion that there is no generalized demand that the victim belong to a different party than the perpetrator. So in that sense, I think it's a very important contribution of the judges of the ICC. We have Judge Van den Meijden, that if I recall correctly, she was the presiding judge of that particular decision, so I will shut up before she tells me that I got it wrong. But I mean, this is... But she's here for questions as well.
So, and we do need to speed up the velocity of this. So, Norman, briefly, what is the most important development in the Special Tribunal for Lebanon?
For those of you who don't know, the Special Tribunal for Lebanon is, we're engaged in prosecuting persons responsible in Lebanon for the killing of the former Prime Minister, Rafiq Hariri. The allegations are that there are, at the moment, 4 members, all associated with Hezbollah, that carried out this assassination. In brief, the progression of the evidence in the trial and the transforming of lead evidence or intelligence evidence or background evidence into evidence of guilt, that has been the most difficult and I think the most progressive development that I think the tribunal can point to. This is not a case where there is human source evidence, like witnesses on the ground. This is not a case where there are insiders. This is certainly not a case where anyone has decided to plead guilty or given admission of guilt. And so the transformation of a new investigative techniques, including new technological techniques and telecommunications data, as not only the means to start the investigation, but as a means to try and prove the guilt of the perpetrators on the ground. When you don't have their identity, everything you have is false. They work in individual cells, as in a terrorist case, where those cells never communicate, and there's no linking the cells to the hierarchy, and then trying to understand how it was done in a manner that was completely covert, without any links to any organized structure, allegedly, and turn all that non-evidence and intelligence information or background information and transform that into evidence such that we're about 1 month away from finishing the prosecution's case. And of course, it's up to the court to decide the result, but the investigative techniques and the ability to present that as evidence in a terrorist case when the nature of the evidence is so different and the investigative techniques are so different than anything I experienced at the Yugoslav Tribunal when I was there and working for the Rwanda Tribunal and other tribunals and in my domestic practice. Hopefully that will be something that we can share with others as a form of prosecution in the terrorist context when you have no insiders or human source witnesses as your primary source of evidence. Thank you.
Thanks, Norman. Evan, the MICT.
Yeah, I mean, from the ICTY side, I mean, the most important development is that we're 4 months away from completing our mandate and closing our doors. At the end of November, we'll have one of the most important trial judgments, I think, in international criminal law history, the trial judgment against Ratko Mladic. And we'll have one of the most important appeal judgments in the ICTY's history, the appeal judgment in the case against Perlich et al. But I hope we can talk about the ICTY and its legacy a bit later. So just to talk about the MICT, the mechanism. The most important development for the mechanism is the beginning of the retrial in the Stanisic and Samatovic case. Why is this so important? From our perspective, this is our last opportunity for the conflicts in the former Yugoslavia to address some of the real gaps that are still outstanding in the ICTY's legal and factual legacy. This is particularly an opportunity to get back on the right track after what I consider the disaster of the Perisic appeal judgment a couple of years ago. Factually, why is this an important development? Stanisic and Samatovic are two of the most senior officials in the Serbian secret services, so a combination of the CIA, FBI, NSA, all those kind of organizations. And what we argue in the trial is that they were tasked by Slobodan Milosevic to implement and support ethnic cleansing campaigns in Croatia and in Bosnia. Unfortunately, however, we have not yet secured any convictions of Serb officials for crimes in Bosnia. So this is our last chance to really enter into the factual record, what we believe the evidence proves, what we've secured findings on in other judgments, but that there was a joint criminal enterprise to commit ethnic cleansing in Croatia, in Bosnia, and that involves senior Serbian political, military, in this case, secret service officials. So this is really an important case for us to hammer that issue of Serbia's responsibility for these crimes. Similarly, as I said, legally, this is our opportunity to get back on the right track after Perisic, and particularly this erroneous notion of specific direction. Like in Perisic, who was acquitted on appeal, at the original trial, Stanisic and Samatovic were acquitted based upon this erroneous notion of specific direction. Thankfully, the Taylor appeal judgment at the SCSL and the Shajinovic appeal judgment at the ICTY have sent specific direction to hopefully the waste bin of international criminal law. At the same time, and perhaps even more importantly, Stanisic and Samatovic legally is about, on our side, ensuring that the law is appropriate to hold people accountable for the acts of aligned irregular forces, particularly paramilitary forces. This is particularly a big gap in IHL and ICL today, and you just have to look at what's happening in Syria today to understand the vital importance of this kind of attribution and liability. So what we're really looking to do is prove that even though there was not a unity of command, that's absolutely clear, there's not a unity of command between the paramilitary forces and other forces and individuals, there was a unity of effort, there was support, there was cooperation, there was coordination, and we really hope to show that the law is developed enough to hold people accountable when there is that unity of effort and that kind of cooperation with irregular armed forces. So, as I said, in Syria today, where you see multiple groups, very confusing and difficult lines of chains of command to understand, but clearly there are cooperation ongoing. So that's why I think this case is really going to be very important for the future of accountability in international criminal law.
Now, Nick, since we heard a lot about the developments last night from the ECCC, I want to ask a very specific question about something that wasn't discussed last night, but I think is going to have a very significant impact. And that is the November 2016 decision of the Appeals Chamber that Joint Criminal Enterprise 3, the extended form, does not apply to the crimes before the Cambodia Tribunal, which occurred in 1975 to 79, because it had not yet ripened into a principle of customary international law at that point. Tell us a little bit about what you think the significance of that is to your case, and maybe how it might have significance beyond Cambodia.
Okay, thank you. It had very little significance in affecting the judgment in case 2-1 because we were not relying upon joint criminal enterprise in the third form. And so technically, in fact, while we had appealed a decision by the trial chamber upholding the pre-trial chamber decision that joint criminal enterprise in the extended form was not part of customary international law in 1975, the Supreme Court didn't hear that. But in discussing joint criminal enterprise, they rejected our appeal as not right, but they more or less dealt with it in discussing the first form of joint criminal enterprise. So, and one of our arguments, which they didn't deal with at all, is what is the whole point of the principle of legality, which we feel the pre-trial chamber, trial chamber got mixed up. Principle of legality is a fundamental fairness. You don't punish someone for conduct that at the time they had no reason to believe was illegal. You know, if there's no law against copying CDs and suddenly you change the law, you can't then arrest people who had copied CDs the day before and charge them with that. What we argued is joint criminal enterprise should be viewed as a whole. And to say that joint criminal enterprise of the first degree was part of customary international law, in other words, entering into an agreement, plurality of persons, to commit a crime within the jurisdiction of the court, and then say, oh, but you didn't know it would be extended, your liability, to other crimes that were foreseeable. To me, that's overextending and misunderstanding the basic principle of the concept of legality. So, in our view, if you order millions of people to leave a city within 24 hours, and crimes are committed against them, and if you order young soldiers to detain, torture, and execute young women, and they end up raping them, those are not, there's no issue about the person's conduct being unfairly criminalized. They didn't know that ordering those killings, those torture, or the evacuation of those cities was illegal. They rejected that. And they basically looked at the World War II case law. We had given our arguments of why various decisions, such as even in the IMT judgment itself, the Spear, when they talked about Spear. The problem in reading all of those World War II cases, they don't really talk about modes of liability. It's not clear what modes they're using, what crimes they're actually even being convicted of. So it all is a matter of sort of art in interpreting what it was that they were talking about. But in case after case, and Spear's an example, they said, he was responsible for the slave labor and organizing that. He probably didn't want the abuses that occurred, the killings and the tortures of that, but he knew about it, and he still participated in the slave labor program. In our view, that's an example of extending joint criminal enterprise to crimes that are foreseeable, a result of the criminal plan. But that was rejected. Now, what effect does it have? In a way, we lost and maybe we won, because there was another issue in the case, and this is what the Supreme Court was dealing with. What does it mean to have the intent for the first form of joint criminal enterprise? All the cases from the other tribunals talked about, you have to have a plurality of persons who have the intent to commit a crime within the statute. The trial chamber had talked about these crimes and said, for example, that when they ordered the evacuations of the city, they were aware of the substantial likelihood that the crimes would occur. So, is that intent or isn't it intent? What we argue on appeal, the prosecution, is that the intent should be at least what in civil law is called the two forms of dolus directus of the first and second degree. That you're either aware, either that's your conscious objective, that's your direct intent, or of the second degree indirect intent, you know that it's a likely result of the conduct that you're engaging in. And different legal systems use different words to express that, whether it's in the ordinary course of events. There's various languages that are used, but I think it all expresses a similar concept that in criminal law, every day in courts, you hold people responsible not just for what this is the intent, the objective of what they wanted from their conduct, but also this is what they had a good idea was going to happen in their conduct. If someone drives a car on a sidewalk to get away from the police, crowded sidewalk, and they hit people, that may not have been their objective. They just wanted to get away. But clearly, they would be held responsible, I think, in any court for murdering those people because it's a result that they could definitely foresee that was likely. So, what was interesting about the judgment is the Supreme Court went a little further in some ways than we had asked for or used a different approach. They said, well, intent means the intent for the crime. And so if it's a specific intent crime, then the accused person would have to have the specific intent. So specifically in our case, we had charged exterminations and murder. Extermination requires the intent to kill on a mass scale. So they said, oh, you'd have to show that they had the specific intent to kill on a mass scale. But they said for crimes of general intent, such as murder, they held that dolus eventualis would apply. They said dolus eventualis, murder can be, dolus eventualis is applicable. And I presume that would be the same, we didn't have that in that case, but crimes like rape. One of the reasons we appealed this JC3 is we think it's very important for sexual violence, particularly holding leaders responsible. They may not order rapes, but they order conduct and criminal policies that where rape is a foreseeable result. What they held in the cases for dolus eventualis crimes, general intent crimes such as murder, all that is necessary is showing that the accused was aware that it was a possible result and they reconciled themselves with that. It's classic civil law, dolus eventualis formulation of intent. So they made the standard higher, much higher than we wanted for specific intent crimes, but they actually made it easier to prove responsibility for what really amounts to an extended form of joint criminal enterprise for the first form of JC.
So, ever since the Tadic Appeals Chamber decision, the Yugoslavia Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, looking at Duncan Gazwaga in his piracy cases in the Seychelles, they used the extended form of joint criminal enterprise. I think General Martin, you use it in your military commissions. It's been spreading. I think it's currently thought of as customary international law. But that's not necessarily the case at the ICC because they have this alternate theory called the control of the crime principle. Fabrizio, can you explain that to us?
Yeah, I think it's not so much that we have an alternative theory, it's that basically we apply treaty law, not international custom law. For us, the principle of legality is linked to the crimes as defined by the statute and the most liability as defined by the statute. So in a way, we have the advantage that we can sidestep the whole discussion of what was international custom at a given time, because what we do primarily is we apply treaty law. It's a matter of interpreting the provisions of the statute as such. Yes, the court can have resort to international customary law under Article 21, basically just to look at how just to better interpret the provisions of the statute. But the answer to a number of those questions for us lies on the text of the law more than in the depths of international customary law. For us, JCE3 was off limits in any event. And that's because we have a heightened mens rea. So we have a mens rea in Article 30 of the statute that basically captures direct intent, and something that is certainly more than dolus eventualis, but probably less than a dolus of unavoidable consequences, which is what the statute basically says, that you are responsible for those consequences that occur in the ordinary course of events. So it's not a mere risk that a consequence might occur. It's something that basically under the following the words of the appeals chamber in Lubanga, it's virtual certainty that a consequence is going to happen as a result of your conduct. So it does limit us, that is obvious. I mean, we have, in the context of attribution of criminal liability, we have a heightened burden in terms of establishing mens rea. It's not an insurmountable obstacle. Basically, we have been able to work around it. But going back to your question, yes, what we have is primarily the statute defines as a perpetration jointly with others or through others. And the case law of the court has interpreted that as somehow embracing the concept of control over the crime. So you are responsible if you make an essential contribution to the commission of the crime through a common plan. So there is a heightened actus reus compared to JC that requires basically a contribution, well, an essential contribution in the sense that the crime would have not occurred in the same manner had not been for your contribution. So your absence of your contribution would have significantly complicated the execution of the crime. And then obviously there is a shared mens rea in the sense that basically each co-perpetrator is aware of the contribution that he or she is making to the common plan. And that can be normal co-perpetration or can be co-perpetration through others, indirect co-perpetration, which is something that we have used with some frequency in the cases of military commanders. Basically, people use structures of power as a tool for the execution of crimes. It is linked to developments in the civil law criminal theory. Obviously, I mean, it comes from a German scholar called Klaus Roxin, who basically started developing this theory when he was analyzing World War II cases and the crimes committed through the Nazi structures. It is handy. I think we believe it is a theory that tends to explain in a comfortable fashion what ends up happening in a number of these crimes. It has some clear boundaries. It's not a panacea, no legal theory is, but it's one that basically I think is developing very nicely in the ICC. And then we have common purpose liability at the other end of the spectrum, which is a residual mode of liability that basically captures less forms of contribution. There is no particular threshold for the contribution. Basically, any contribution in principle with the corresponding mens rea suffices. And then what we penalize more is not so much a contribution to the crime, but a contribution to the group that is behind the crimes, in the awareness of the criminal agenda of that group. So it's something that basically is there between conspiracy and aiding and abetting.
So this JCE issue really illustrates one of the aspects where the tribunals have been most divergent. In many areas, however, the tribunals have been looking at each other's precedent and being guided by them. Let's change tracks and talk about one of those. Ever since Slobodan Milosevic died of a heart attack before his trial was over, keeping elderly and ill defendants alive through trial has become a recurring challenge for all of the tribunals. Kevin was just mentioning the Stanisic case. Last week, his court announced that it would try Stanisic, technically not in absentia, but without his presence, because he waived his right to be present, and he's going to watch the proceedings from back home. But all of the tribunals, and we heard a lot from the Cambodia tribunal prosecutors last night about the challenges of trying people that are in their 90s. Tell us how the tribunals have generally dealt with this challenge of keeping the defendants alive and how that has made it more difficult for your prosecutions. Anybody can jump in. Yeah, Kevin.
Happy to talk about this because, as you mentioned, we have this issue with Stanisic and Simonovic. But just to kind of step back a second and say, how do we deal with this generally? To put it kind of bluntly, we deal with it generally by providing these defendants with some of the best medical care available in the world. It's kind of a little bit ironic, but Ratko Mladic has repeatedly praised the tribunal for keeping him alive. He has said himself that I likely would have died if I had not been arrested and treated by you. So that's one way that we deal with it. The Stanisic and Simonovic situation is really quite interesting. So you often have the case where, yes, we do have defendants who are ill, who are getting quite old, We've had situations where trials, a number of situations, in fact, where trials have ended without a judgment, most recently in Hodge's case, due to the death of the accused during trial. So one way we deal with this is really trying to encourage the judges to be as expeditious as possible. But the Stanisic precedent is really quite interesting because it shows that, in a way, we tend to think that maybe perhaps the accused, and Slobodan Milosevic is maybe a bad example in this, because we believe that, it wasn't against his will to die during the trial. He probably did not want to see the trial end. But in this case with Jovica Stanisic, he does want to remain very much alive. He does want to be with his family during this difficult time. So between the OTP and the defense, there was a unity of interest. He wanted to be with his family and to get his medical care. We wanted the trial to proceed quite expeditiously. So there was this decision by the trial chamber, which we support, that he will be able to remain at his home, receive his medical care, be represented by his counsel. He's waived his right to be in the courtroom, and that's going to allow us, hopefully, to move from a trial schedule of maybe 3 sitting days a week to 4 or perhaps 5 sitting days a week. So in the end, because he wants to be at home and because we want to have a case be proceeding expeditiously, hopefully this trial is going to end sooner than it would have been, and hopefully we'll get a conviction that may have been at risk if he had been in the courtroom during the trial itself.
Now, Norman, it's not for illness, but for the failure of the local authorities to surrender that your tribunal was set up with the idea, and you've implemented the idea of trials in absentia. So you've got defense counsel who've never talked to their clients, I assume. How have you dealt with that challenge?
Thank you for the question. First of all, no accused have been arrested at our court. And so the trial is proceeding with just the prosecution and the defense counsel in the courtroom. And 4 accused have remained at large. To answer your question, Michael, first of all, from a prosecution point of view, we still have to prove the case beyond reasonable doubt, and we still have to call all the evidence that is challenged effectively by the defense. So there is limited impact, or less impact on the prosecution. In terms of the defense, I think it's more difficult for the defense to deal with the situation. They have no accused, they have no client, and they have no instruction from the client. And therefore they're running their defense based on their alternative theory or just challenging the prosecution case. They don't often have their own defense theory without a client. The one thing I will note, which I've raised before, though not in this context, and it will get some response from the defense counsel, but I stand by my position wholeheartedly, is that the defense counsel have raised since the beginning that they cannot agree to any facts, cannot take any position on any facts because they don't have a client. Yet when they want facts to go in that assist their case, they're more than willing to agree that the prosecution case goes in a particular manner. The inconsistency of this position is backed in part by the view of some of them that they would be in violation of their National Bar Association if they actually agreed to certain facts to go in. It took 6 months after I arrived to get the defense counsel to agree, or at least not to object, that Rafi Kariri died. That was a waste of time, and I don't think there's any legal principle that would prevent you from acknowledging that. And it has had an impact on the way in which we present the case and present the evidence. They would take a different view that they're not, that they don't feel they can, but quite frankly, my view is they're not working in their national jurisdiction. In my national jurisdiction, I could not prosecute anyone in absentia. It's not permitted. So unless I went to the Secretary General and said, look, thanks for the appointment, but I'm going to get in trouble at home by my bar association, we work in a different system, and we're bound by the rules of that system, and I think there's no reason, despite all the difficulties the defense face, there's no reason why they can't look at their case and decide on which they're really going to challenge and save us the time of presenting evidence that's really not in dispute. Thank you.
And Nick, last night you were telling us that one of the ways that your tribunal has dealt with this is by severing the case and dealing with a shorter, more compact trial first, and then having the more complex genocide trial come later. I'm reminded when Mike Newton was out in the audience and I were helping with the Saddam Hussein trial, they had the same theory, And after they tried Saddam for the Dajjal case, and then he was convicted, then he was hung and wasn't around for the genocide case, they said it was like trying Al Capone for tax evasion and not for all the murders. Is there a sense in Cambodia that if the defendants do not live for the end of the bigger trial, that there is some kind of a missed opportunity through this strategy?
Well, I think absolutely. I mean, there definitely were compromises, and that was not I think the prosecution opposed the decision at the time, at least asking to extend the charges for the first phase to include this famous tool slang S21 school where, I think when Andrew left, he's correct, the figure was 12,000 names recorded as having been executed. We've updated those lists, and it's about 18,000 people now that we have named who were executed at that school. So to answer your question, yeah, I think it would be, a lot would be seen to have been missed if we didn't try the forced marriage, we didn't try the rapes in the forced marriage, we didn't try the genocides, we didn't try the security centers. That would have been a bit of a tremendous loss. So hopefully the accused live through at least the trial judgment.
You know, the very first time one of these international tribunals dealt with somebody who died right before the judgment was the Dokmanovich case. And it was not clear under the precedent why at that point, since the trial had completely concluded, but the judgment hadn't quite been written, they couldn't have just gone ahead and submitted their judgment. Ever since then, it seems to be the case that if a defendant, the last defendant in the case is dead, the tribunal just packs up and doesn't issue a decision. Is that a good policy, or are we somehow erasing history from being written? Go ahead.
I think that if you accept as an internationally recognized human right the right to have your conviction appealed, among other things to clear your name, and prevent a wrongful conviction, if you're dead, that's the end of the story, right? Your right dies with you, unless you establish some sort of compensatory measure, for instance, allow for the family members of the deceased person to appeal on that person's behalf. We have something like that with revision. So again, it's borrowed from the European continental tradition that after the convicted person has died, a plea for revision can still be brought forward by those two surviving members of the family. But it seems to me that when the person has died, the criminal process dies.
Go ahead. Yeah.
I just want to say really quickly, I mean, obviously none of us want to see the accused pass away before the trial judgment, but it's really important not to forget that in most of these cases, when the prosecution has completed its case, that means we put the evidence into the record. The facts are in the record. So yes, there isn't a conviction, there isn't a judgment, but for the legacy, for the future, for the people who suffered the crime, the facts have been entered into the record, and I think that's extremely important. It's not something we should forget.
Go ahead.
Just so that in the one of the cases tried by the SESL, the CDF case, we did have a situation where one of the accused persons died after the trial was completed, Hinganong, former Minister of Defense, and had been sent to the country for treatment, and then he died. So the process was simply was considered that nothing more could be done for that this person is died, and so the case was discontinued against him, and it continued on with judgments against the other two accused persons.
And partly it's a good idea to always have another defendant there who's maybe a better help in case that happens, because otherwise you won't have history written. Let's go to one of the big picture challenges that are facing the international justice community, and it focuses on countries throughout Africa and the African countries failing, or in some cases refusing, to turn them over to the ICC. So the question is this: what do each of you think, and it may be something that Fabrizio has trouble being completely candid on because of political constraints, but maybe the others of you are able to think about it from your perspectives. What do you think will be the future of Africa's relation with international criminal justice? Mohammed, do you want to start us off?
Thank you. My belief is that that relationship will continue. notwithstanding the posturing, I would call it, that we have seen in recent times, headed by countries who had a good reason, were not good for the rest of us, but they believe they had good reason for wanting to pull out of the Rome Treaty. But in fact, we have seen that we've seen some reversal of those decisions already in the case of Gambia and in the case of South Africa. I say that the relationship with African countries and the ICC will continue because, first of all, it is premised not on even though it's a multilateral treaty, the Rome Statute, but the relationship is premised on a bilateral basis, meaning that every state has to maintain that relationship with the ICC. So you want to see the number of states that actually are not very much supportive of the idea of pulling out of the ICC. But let us take it even further. The African Union, African states generally have gone on to now try and create an African court. Basically a court which also now will address violations of international humanitarian and various other crimes. But they've also included in their statute, they've made provision for the principle of complementarity, meaning implicitly that if by all their means, any state is not able to exhaust those means, then the African court can try any situation where there's been a violation of...
Mohammed, doesn't the African court have something different than the ICC, and that is that there is head of state immunity?
Oh yes, of course.
So like the one thing about the ICC is if they say, well, we can't prosecute because he's the head of state, then the ICC said, well, send him to us. With the African court, you can't go anywhere for the heads of state.
Oh yes, but my feeling generally is that you must, the principle of complementarity, to understand, is simply that you exhaust those whatever remedies you have, and if you cannot, then the case comes before us. And if you are still a member of the ICC as a state, then it means implicitly that you can actually you can have the ICC deliberate on a matter which involves a violation of crimes.
And Fabrizio, I know FATU is spending a lot of her time reversing some of these initial setbacks and has been successful. What has been the general strategy of your office in light of
the general strategy of the office has been that the office has to continue to discharge its mandate in an objective and impartial manner, while trying to simultaneously engage with African states and to build forward the partnerships that we have with African states. And I think that one problem here has been the reductionism because we have a few very vocal states that is actually representing a Pan-African voice, and that's not the case. I mean, we had a number of states that are basically great supporters of the court that have been working with us, and they're much more silent and they're much more intelligent in a number of ways. They are basically building support for the court in different ways. But at the end of the day, we also, I mean, this was a challenge for the court. It was a challenge during 2016. It was obviously something of concern to us. But at the end of the day, the Gambia has returned to the ASP. South Africa has withdrawn its withdrawal. We have Burundi left there, and Burundi, in a way, basically has good reasons, perhaps, to try to evade the scrutiny of the court. I will not say anything else right now. So I think that we need to put this in its proper dimension. I think that in any event, there was a conversation to be had with African countries as to the model of international justice, how they want to develop their relationship with the court, and we are engaged in that conversation. And that is, I think that this is an important piece of things. At the same time, I think something that is very important for everyone to know is that at the operational level, we kept working with our African partners. Cooperation was forthcoming by and large. We had some glitches, serious ones like in the Kenya cases, but we have been working with African colleagues. We have been basically obtaining the cooperation that we need to with our cases. We have been promoting and supporting domestic efforts, so we're training local prosecutors, we're building capacity wherever we can. So there is a much richer story to be told there than the narrative that sometimes we're getting.
So related to that is the question of the international politics of international justice and how it affects what you all are trying to accomplish. So, at the Special Court for Sierra Leone, I'm sure prosecuting the former head of state of Liberia was enormously challenging politically, but Dave Crane has also spoken about how they contemplated at one point prosecuting or indicting Muammar Gaddafi and felt that might be a political bridge too far. At the Cambodia tribunal, you talked to Nick last night about how your co-domestic prosecutor has marching orders and that you have to spend a lot of time working on compromises to try to even get the minimal cases that you can get the common denominators moving forward. At the ICC, we have some investigations that have sparked a lot of controversy in the last year. The Ukraine investigation, which has had Russia say, we may be withdrawing. The Afghanistan investigation that has the United States all nervous. The Gaza investigation that has Israel actually playing a constructive role, but probably at the same time nervous, and all of those are politically charged.
You have opened 3 investigations, so we haven't opened, Michael.
What are they? What are they charged? They're preliminary examinations. Thank you. Let's keep the record clear on that. But they've had this aspect of political outcries, political charge, nervousness among the international community. So would any of you comment on how you have dealt with, as a prosecutor, the political milieu that your court operates in? Go ahead.
Since part of my job description is political advisor, I think I can probably address this question. I think one of the big lessons from the ICTY is that, as Prosecutor Bremertz repeatedly says, prosecutors have to admit and understand and accept that they're working in the real politic world. Our objectives, our goals, our prosecutorial decisions can only be guided by our ethical obligations and the facts and evidence that we have. However, the methods, the timing, how things get done, these are ultimately questions that involve very significant political questions. So at the ICTY-OTP, from the very, very early days, and I'm sure Norm could talk about this more, there was a political advisor, there was a diplomatic advisor. The chief prosecutor understood that one of the primary functions of that position is to be a diplomatic actor. Again, the decisions that are being made, crucially the prosecutorial decisions that are being made, are only guided by the evidence and our ethical obligations. But we do have to recognize that to obtain the surrender of accused, to ensure that we're getting the right evidence, we have to go out, we have to build support, we have to negotiate with the diplomatic community, we have to negotiate with, in fact, the countries that are the targets of some of these investigative activities. So that's the reality. We can't shy away from it, and we need to really embrace it and understand that we have to have lawyers, we have to have trial attorneys, we have to have investigators, and we also have to have people who are performing that diplomatic and political advisory function to ensure that our offices can get the things that we need to be successful in our work.
It's interesting because a couple of years ago, Richard Goldstone, who had launched the very first Yugoslavia tribunal prosecutions, said over and over again that his job as a prosecutor is to ignore politics and just follow the evidence. And I don't think anybody ever believed that was true or that was the best approach. So to hear that there's a much broader strategic approach from you at the ICC is very interesting. Nick, you've had a lot of experience with this. Do you want to add?
Well, I want to defend a little bit what Goldstone said. I also worked in East Timor, where there was some difficult political issues, because in that case, a very, very small country, we had investigations ongoing, and when I was there, we got an arrest warrant against General Wiranto, who was then the candidate to be president of Indonesia, nominated by the largest political party. The government of East Timor was quite against pursuing any of these investigations, and the arrest warrant particularly, but for understandable reasons. They're a very small country. These internationals are going to be there a few years. Our borders are going to be with Indonesia forever. We need to get along with them. But it reminded me of in prosecutions, doing domestic violence cases. A woman comes in after being beaten, and she says, gee, I don't want to go forward with this case because I need my husband's paycheck, and he's the father of my children, so I want to drop it. And we eventually recognized in that situation, to protect the woman and to protect, to deter future conduct, you simply had to ignore her wishes. The case had to proceed. It's unfair to put the burden on her to decide whether or not the prosecution would go forward. And that had to be done by the prosecution, and I think in some ways the international community has to take the burden off some domestic actors in making these decisions. The one thing I would say, while certainly you have to deal with cooperation, with real-world issues in all of these cases, what's very important and critical is that the prosecutors and international prosecutors maintain their integrity, that you're doing things for the right reasons, that you're not indicting people without evidence, that the first thing you look at, yeah, you may be other considerations, but the first thing you look at is the person guilty? Can we prove it beyond a reasonable doubt? You know, those are critical, and transparency, as much as possible, that the process be transparent so that people can judge what has happened, and if there's a failure, for what reason, who is responsible.
Let me ask one last question before we open it to the audience, and that is a question for Fabrizio. So put two in your office's September 15th policy paper on case selection and prioritization from last fall has been read in the press anyway as suggesting that the prosecutor is interested in going after corporate officers, potentially for crimes against humanity related to the destruction of the environment. Can you tell us a little bit about the background of that policy? Is that a fair read, that the press, a fair spin that the press has given to it?
I think it was a misunderstanding. It was fun because when I saw the International New York Times at home, when I saw that our policy had made to International New York Times, I thought something has been misread here. Because this is not the type of stuff that makes the headlines. And of course, it was the issue of the environmental impact. No, we have not added any new crimes or new modes of liability. What we have done simply is we said that when we look at a cluster of crimes and we try to determine which crimes we want to prioritize, it's something that we're trying to do more and more. The ICC is in a complicated spot. I mean, we have very limited resources, we have growing demands, we have multiple situations queuing up. When we open a situation, there are myriad of cases that we could investigate and prosecute, but we are forced to make choices. And what we want to do was basically, there is a whole discussion with state parties as to whether we should be demand-driven or resource-driven, how far we can go in terms of expanding the structure of the court in order to meet that. The reality is we have to make painful choices and we need to select cases, and what we wanted to do was to be transparent about it, to show to the world the criteria that we were going to use to make that selection. It was the policy paper is a result of a wider range of consultations internally and externally. But what we're saying is one of the things that we're going to look into is the manner of commission of the crimes, and we're going to look at the impact of the crimes. And within both manner and impact, the issue of extensive destruction of the environment is one that we're going to consider. Either because, for instance, you committed the crime of persecution or forced displacement by destroying the environment and forcing the communities out of a given geographical area, or because the way you attack the civilian population caused an extensive damage to the environment. But that's as far as it goes. It doesn't write anything new. It just simply adds one element to the set of factors that we're going to consider.
I wonder if intentional or not, this has sent a signal to corporations to be more careful. This was a signal that Nuremberg wanted to send when they made Krupp one of the defendants. It was a signal that the Rwanda Tribunal had sent when they went after the tea companies and the media defendants.
I think it was more like picking up the lessons of history. I mean, we know through the experience of the ad hoc tribunals and other tribunals that these crimes cannot go this way. I mean, if you look at the Kosovo campaign conducted by Milosevic, part of that campaign was a scorched earth policy, right? So basically what we do is you destroy absolutely everything. You destroy the crops, you kill the animals, and you force the population out. But you also make sure that they don't return, because if they return, then the winter is going to kill them because they have no ways of surviving, right? So these type of forms of victimization do happen. There's at times they they operate under the radar screen. People don't realize how central they are to the criminal plan and how devastating the results are for the civilian population. But basically, these are the type of things that happen, and these are the type of things that international criminal jurisdictions should tackle, one way or the other.
First of all, the legal basis for the Lebanon Tribunal was initially was an attempt between the Lebanese government and the United Nations Secretariat, Secretary General and the Secretariat, to reach an agreement for an investigation. That never happened. And so there was a proposal by a number of states before the Security Council. When the agreement failed, then states proposed under Chapter 7 under a Security Council resolution. That Security Council resolution gives us the authority to investigate, and it's an independent body based in The Hague, as you know, and the payments are voluntary contributions by states. We are not a UN body, so we don't get a regular budget. We spend some amount of time, as the other prosecutors here from similar tribunals know, raising the money from states who support it. In terms of the pursuit of an investigation domestically, the situation in Lebanon was that there wasn't an effective, there was a finding by the Security Council that there wasn't an effective ability of Lebanon to investigate and prosecute this case. So it had to be brought to the international level and an assessment made as to the capability of the domestic jurisdiction or willingness to proceed. That's the first step. If it's not brought to the attention of the international community, where there are other alternative means for the creation of criminal investigative institutions, and if it's left at the domestic level, then of course you're left with whatever the domestic decisions are.
Has been the backward trend in national war crimes prosecutions in the countries of the former Yugoslavia. Prosecutor Bramers has spoken about this repeatedly to the United Nations Security Council. We are regularly seizing this issue with the European Commission, European states, the United States, anyone we can speak to. Yet we're seeing very little effective action, we're seeing very little change. Most recently, one of the real setbacks was the first Srebrenica genocide trial in Serbia has now been revoked due to a purely formalistic reasoning by the Belgrade High Court. It's extremely disappointing. The victims are absolutely devastated. It took years and years and years of efforts to get this case transferred to Serbia, to get them ready to prosecute it, and to have the court revoke it solely because the prosecutor who was acting at that time had not been formally appointed by the Republic prosecutor is just really a disappointment. But we're seeing this repeatedly, where I'd say 5 years ago the trend was very positive in national war crimes prosecutions. It's dramatically reversed. The only bright spot I find today is, surprisingly enough for those who know, in Bosnia and Herzegovina. Due to a lot of engagement, particularly by our office, in the last year and a half, the situation has changed in Bosnia. They now are on the right track. We're seeing some really incredible prosecutions and investigations. For the first time in relation to the conflicts in the former Yugoslavia, the Bosnian prosecution has issued an indictment that was confirmed for crimes against humanity committed by Bosnian Croat forces against Bosnian Serb civilians in the Posavina region. I mean, that's an enormous precedent. Even our court did not issue such an indictment. So Bosnia, there is a big change. It's going in the right direction, but more generally throughout the region, politics, denial of crimes, hero worshiping of convicted war criminals, these things are getting worse and worse.
Kevin, can I ask you a follow-up? And that is, the tribunal was designed by the Security Council in part to facilitate reconciliation. Outside of Bosnia, is it failing to do that 20 years on?
I think the tribunal has facilitated reconciliation in the sense that accountability is essential for reconciliation. Is there effective reconciliation today? No. Is that partly the tribunal's responsibility? I would say, of course, yes, because we definitely did not do enough in terms of outreach, in terms of explaining our judgments, in terms of engaging with the communities. But, and I really don't want to be seen to pass the buck here, but I honestly believe that the primary responsibility for the lack of reconciliation is with the national authorities, with the national politicians who are continuing to use the politics of ethnic division, the politics of divide, the politics of hatred to secure power, and the failure of the international community to hold them accountable for that. I mean, the European Commission, the United States, I think have not been nearly strong enough in explaining to these countries and to these officials that the denial of genocide is unacceptable, that hero worshiping of convicted war criminals, generals who oversaw ethnic cleansing of 800,000 people is unacceptable. There needs to be more strong words and views by the international community to these local actors.